May I please, your lordships? Lordships, I'd like to mention item number 11, lordship. The conducting counsel is not well, lordship. The matter may be adjourned for the day.
Also represented on the player made by counsel for the petition, passed for the day.
Mind that item number 6, matter become infractuous.
6.
6. W is a criminal word here. That is part of.
Upon instructions, Mr.
L. Deca.
L. Deca, learned counsel for the petitioner, has submitted that during the pendency of this writ petition, this matter has become infractuous. So and so are present. So the matter since dismissed, having been rendered infractuous.
Obliged.
May please, Lordship. Lordship, recommend item 32, Lordship. Lordship, conducting advocate Mr. M. is out of station, Lordship. Kindly adjourn for the day, Lordship.
32.
32.
32 is 2019 matter. Please wait till the matter is called.
He's out of station.
It's okay. We'll adjourn it, but not without looking at the records.
Oh.
May please, your lordship, kindly allow me to see the case records from the item number 9, my lord. Obliged.
May it please, your lordship? Lordship, with the consent of the other side, I beg to mention item number 35. Lordship, the decision to be made in this writ appeal is directly based on the outcome of a review petition which is pending adjudication in the Honorable Supreme Court, and a similar batch of writ appeals are pending in the Honorable Chief Justice's court, which is fixed on 22nd of April, Lordship. 35. 35. Lordship, kindly any other date after 22nd, since this matter cannot be taken up by Honorable Justice A.D. Chaudhary, Lordship. Kindly after 22nd.
Both sides are represented on the prayer made by learned counsel for the appellant. The matter stands adjourned today. List on 27/4/2026.
Much obliged, lordship. May please, your lordship. Item 4, my lord. Already Nagaon advocate of Nagaon bar have taken it a file from me. Since then, I have no any communication. So my name is struck down from that post.
No, we can't do that. There is a procedure prescribed under the civil High Court rules. If you have not followed that, we can't strike out the name.
Obliged, my lord.
For motion, item 1 of daily list.
May please, Lordship. In this case, my lord, my lord, the case may be, my lord, fixed for admission here, my lord. Today, my lord, I am not ready, my lord. My mother is my lord. Matter fixed on another day after 4 weeks, my lord. Yes, after 2 weeks, my lord. Yes. My lord, earlier, my lord, Yes, my lord. Just 2 weeks, my lord. I'm not prepared to them. Obliged, my lord.
Item 2,
May I please, your lordship? Checking exam.
Pass over it. No number goes on.
Lordship, kindly pass over for timing, lordship. Right.
item 3,
My lord, the present petition is preferred against the order passed by the learned Foreign Tribunal, Lakhimpur, dated 29/3/2019, by which the petitioner was declared that he entered into India after 15 March of 1971, my lord. My lord, the petitioner, the petitioner is originally the father of the petitioner. My lord. Yes, my lord. My lord, my name of my father is Musuruddin, my lord. Sometimes he is known as Haji Musuruddin or Kazi Musuruddin, my lord. And his name was shown in the voter list of 1966, my lord, which I have annexed at page 16, my lord, annexed at 3, my lord. Page number 16, my lord, type copy, my lord. 1966. My father's name was Musuruddin, Haji Musuruddin. But in the voter list of, and his age was shown as 35 in the year 1966. But in the next election electoral rule of 1917, his age was shown as 38. Only one or 2 years difference, my lord. That was not relied upon by the learned tribunal below, my lord. Page 16 and page 20, my lord, will clarify the discrepancy, my lord. only 1 year difference, my lord. That was not considered by the learned people.
You with your father?
Yes, my lord. My link with my father, Haji Musuddin, is to prove it. I have annexed the copy of the Jamamandi, my lord. Jamamandi, we have annexed it, translated copy also annexed, my lord, at page 10, my lord. And page 10. Musuddin at para 3, subpara 1, Roman 1. Musuddin, son of so and so, and after his death, our name was entered into at page 11 at the top. My name is serial number 15.
Which is your entry in column number 10?
My lord,
In column number 10, which is the entry?
column number 10, my lord. Yes, my lord, remark column. As per order dated so and so, pass by the assistant settlement officer of on application number so and so, a plot of land measuring 9 biga and so on lesser settled in the name of Mosiruddin Jasimuddin in the year 1987, my lord. Land was settled in the name of the father of the present petitioner in the year 1987, my lord. And both are brother, my lord, Mosiruddin and Jasimuddin.
Your name is serial number? Serial number?
Page number 11, my lord, remark column, my lord.
No, no. Your serial number is in that page 12. What is your serial number?
Yes, my lord. My name is at the last part. Serial number,
Last is
my
Sona
lord,
Ali.
12, my lord, 12.
12.
Yes, my lord.
12 is Abdul Hamid. Your name is not
Next,
Abdul
my
Hamid.
lord. Abdul Hamid is my brother. 12, yes, sir.
Abdul Hamid Taki, lady name.
Sultan Mahmud, my lord, all are brother. Abdul Hamid, Sultan Mahmud, Alimuddin, Sona Ali, and Salimuddin. 3 sons of Mosiruddin. And
There is the name of Salimuddin.
yes, sir. Salimuddin is there, my lord.
Where?
Next, my lord, 15, my lord, sorry. Salimuddin is 14, my lord. Very small, my lord.
No. 14 is Alimuddin.
Yes, sir. Salimuddin.
No, no, not Salimuddin. 15 is also not so.
Salim.
Because your English translation has to be rejected. That's not correct. You see, remark number 10, your English translation. You have given the date of 7/6/1980, whereas in
Yes, my lord.
whereas in page 12, it is 30/10/81.
Yes, my lord.
Correct, I think. Third line, the date is 30/10/81.
Oh, yes, my lord. Yes, sir. Maybe
I think it's
typographical.
wrong. Ceremony is something we can't read.
Yes. Yes, ma'am. My lord,
There in any of the voters list.
yes, my lord. My lord, in the remark column last, my lord, it is clear, my lord.
You can't read.
Stopro
If it is clear, I would
Vicar-
have read it.
Yes, my lord. Stopro Vicar from the original. Stopro Vicar 28/6/2018 তারিখৰ নামজাৰি নম্বৰ so and so হুকুম মৰ্মে 163 নম্বৰ 63 নং দাগৰ মাটি উত্তৰ উ দ সূত্ৰে মছিৰুদ্দিনৰ স্থলত
So this, you see, now this shows. মানে তারিখৰ হুকুম মতে
there the son number. The musician was failed.
উত্তরাধিকারী উপরে কি মধ্যবর্তী ফলত Please continue to read that. I'm able to read.
My lord.
Please read it again. Soccer 28/15 তারিখৰ নামজাৰি
Yes, my lord.
হুকুম মতে
I am reading, my lord।
দাগৰ
চক্ৰ বিষয়াৰ 28/6/2018 তাৰিখৰ নামজাৰি নম্বৰ BAR/BARN/2335/FMUT হুকুম মতে 168 নং
63
নং দাগৰ মাটি
163 দাগৰ মাটি
মাটি উদমিজ উত্তৰাধিকাৰী দখল সূত্ৰে মছিৰুদ্দিনৰ স্থলত আব্দুল হামিদ পিতৃ মৃত মছিৰুদ্দিন আৰু সুলতান মাহমুদ পিতা মৃত মছিৰুদ্দিন আৰু আলিমুদ্দিন মৃত মছিৰুদ্দিন আৰু সলিম উদ্দিন পিতা মৃত মছিৰুদ্দিন আৰু সোনা আলী পিতা মৃত মছিৰুদ্দিনৰ নামত নামজাৰি কৰা হয়। So they are son of late Mosiruddin Maila. Last week was all of that.
Matter has to be remanded back. The, we'll show you this, see page 17. This is a part of. From that mutation order,
Yes, Lordship.
that whether it is Salimuddin or not, is that SMS saw, we can't read that word, letter. But in the opinion, the come to page 39. 39, exhibit 5, down below. Here you see, Jama the copy so and so, proceedings name Salimuddin is mutated by way of inheritance. Therefore, the tribunal could have read it and says it has been done. So it is presumed to be Salim. Although I couldn't read that saw, but this is an admitted fact. Now come to this, the next part. Proceeding could not produce a single certified copy of the voter list in his own name. There is no proof that Proceeding has cast his vote. Proceeding has failed to bring linkage with the person Haji Wasiruddin, whom he claims to be his father. Proceeding has not disclosed the material facts about his name of his brothers and sisters, his grandparents, etc. Proceeding has not disclosed about his parents to the date alive by this time. Come to that record. I have
WS, there is mention about the parents.
Yes, see that.
Page,
See,
Same
here we have given a flag,
yes, Lordship.
correct? The second last paragraph,
Paragraph 7.
I forgot that.
Yes, Lordship, it is there.
First he says, mother died when I was so and
And
so,
father
then
died
father
in
died,
2000.
and you and these names.
Yes.
The tribunal has not read it.
Lordship, there's another thing. There's not a single voter list of the projected parents after 1970 also. The continuous stay is not there. His name with his parents is nowhere in any voters list. Though his family history is there, neither his voters list with his siblings. Something, because Lordship, if Lordship sees that the affidavit he swore in 2019, he was 41 years. His date of birth ought to be 1978. That means the first time he votes would be 1998. But he has a voters list only of 2013. Somewhere he has mentioned it. I read it. So, and that too not annexed to the petition. We do not know that voters list is a single name voter list, or with his parents, or with his siblings. On this ground, Lordship, the mutation part, Lordship may be correct, but the other documents, he has no supporting documents to show his linkage, Lordship.
No, but if he's inherited the land, even if he does not vote,
Lordship, the land
his
documents,
citizenship. You see, had the tribunal discarded that evidence because of that, he would have understood. But he says that there is no pleading.
so my humble
If the
submission would be,
tribunal would
Lordship, along with this for a reconsideration, he should produce more voters list to
We are
show
not
his
saying
linkage.
anything. We will not expand the scope of the inquiry.
Lordship would like to restrict it only to the mutation.
Whatever is there, because it's not the case of the
I
petitioner that
will
he
take a
wants
call
to
again, Lordship.
not the case of the petitioner that he wants to get fresh evidence. We are not allowing it to expand the scope of the inquiry.
Lordship, the points I have raised, Lordship may just like to place it in the order, Lordship.
You record that.
Yes, Lordship.
This is why we are insisting on the training part. I think
Lordship is not very audible. Lordship can just put a little bit of volume.
My lord,
you see,
land
that's why
document
we are
sufficient
saying
to show the link with his father, Masiruddin matter.
No, she is right. We would have discarded it. Had this tribunal did not write one paragraph,
Yes.
you have no case at all.
Yes, sir.
Because you are not showing yourself with any of your family member.
Only in the WS, it has to be supported by documents, Lordship.
No, you are absolutely right. You don't show yourself with your siblings.
And father was alive till 2014. At least one voters list with his father, Lordship. Projected father. Or with the siblings. In the absence of voters list, Lordship, it casts a doubt that he has just picked up those documents.
Correct. But had
Out of the five brothers,
half of this wisdom been there with the deciding officer, it would have been a different matter. That's why you have to tell them to have again training programs. How to appreciate documents is becoming a must. And so PP Das will counsel for the petitioner and so for the respondent. Next. By filing this petition under Article 226 of the Constitution of India, the petitioner, namely so and so, has received the opinion dated case 36, 29/3/2019, passed by so and so in Lakhimpur, FT case number so and so, district number so and so, by which the petitioner was declared to be a foreigner post 25/3/1971 street. In view of the order which is being proposed to be passed, the entire pleadings and the evidence available on record has not been referred to. Next, it was suffice to mention that the Superintendent of Police within bracket border, bracket was Lakhimpur, North Lakhimpur, had made a reference by district number, DIST, full stop number 73 of 2004, on the basis of a police inquiry report, expressing doubt about the nationality of the petitioner. Full stop. Upon receipt of notice, the petitioner had filed his written statement of defense and adduced evidence, and along with this evidence on affidavit, the petitioner had has exhibited the following documents: Gauhati certificate within bracket exhibit 1, so elector photo identity card within bracket exhibit 2, voters list of 1966 within bracket exhibit 3, voters list of 1970 within bracket exhibit 4, photocopy of Jamabandi within bracket exhibit 5.
Sharma's very close. What exhibited in the petition? I found it in the opinion, but I didn't find that a copy of. Lordship, if we had annexed it, we would have known if it is his father, projected parent, sibling. That is the burden is on him, Lordship, to prove, to show us the documents. Mere writing without supporting documents is not.
It is that if these documents were not exhibited, the tribunal would have written it in the order sheet that it's not found. But there must be a match between the evidence on affidavit and the opinion. 51, 52, you see, these are the exhibit 6 is there. Now, where are those documents? Ms. Verma, our problem is that both of us have roots in the trial court. So if the documents is not in order, we find it very difficult. We are bound to look at the trial court records.
Not sure about all this in the opinion also.
You see, Mr. Das is very busy. Mr. Das is very busy. He does not have time to read the records. He must know his difficulties.
So sometimes me kindly become that I go through the record.
No, that's very difficult. You see, you all start hearing, taking up the hearing without looking at the records. We are the only one interested in looking at the records. We are highly disappointed. Every day we have to say that
also not available.
that's why
Only
we have
the judgment.
the lawyers prerogative to
Poor
look at the
person,
records.
they could not collect matter, all this matter.
No.
Even the.
You see, how could you have drafted this petition without looking at the evidence?
On the basis of mere the annexes and the impugn judgment, my lord.
The records also submitted to the epic of 2013.
No, even you see the evidence, every serial order is different. Exhibit 1 is that Gauhati certificate, exhibit 2 is the epic, exhibit 3 is the other document. So it's not in serial order. But you see, the problem is that the tribunals break up the records. The evidence is removed from here. It's kept somewhere else, and therefore we can't trace it out.
The whole record comes out.
No, full records are here, but the evidence part that is removed and kept elsewhere. That is why you see we gave an order a few weeks back, saying that the removal of records from one place to another is wrong.
The tribunal has gone forward and asked for authentication of the voter by 70.
That's positive.
Yes.
I have annexed a copy of Jamam exhibit 1,
No, this is the case of 3 wise
4
men.
and 5, my lord.
This is the case of 3 wise men. First wise man is there who's presiding. Second is the lawyer who's there.
Yes, sir.
Third wise man is you.
Party order. Court remanded it back.
It went there, then the evidence came.
Let the evidence do.
But look at this. Look at the evidence.
The petitioner was before this court earlier also in 2018.
That's why we said there's a case of 3 wise men.
Lordship, I would just like to draw Lordship's attention to the conduct of the petitioner, Lordship. His proceedings started in 2008. He came before this court, Lordship, saying that he did not receive notice, ex parte order was passed. 2018, he approached this court. 10 years gone, Lordship, and the reference must have been before that. Again, the matter was remanded back for fresh consideration, and the record shows that he received the notice with his thumb impression, but he never filed his WS, never took any, he never proceeded with the,
But that's all washed away. That is all washed away.
yeah. And then he went back, but this time also he did not go back with all his documents.
So whatever is there, the traveler's duty was to record it in accordance with law and then dispose it off.
Yeah, on those grounds, Lordship may say, but Lordship may not. Only on the mutation part, I feel Lordship should say a complete reconsideration of all documents, whatever is before the tribunal. Because his voters list is not there, his lineage is not proved, neither with his siblings nor with his parents. So that part also has to be looked into, Lordship, because it is not that he is not aware of it. He knows that there is a reference against him from 2008 when he first participated. And I think the inquiry must be 10 years before that.
You have to say something more. He'll show you. Is that? Show you
Okay.
something more.
But para 4 of the judgment shows that I participate the proceeding, my lord, subsequent proceeding and file written statement. Filed by the proceeding with the documentary evidence on the on the record, as well as the deposition made in the proceeding. Therefore, at page 29, it is clear.
Lordship, in my humble submission, he has to prove that his father and they were here.
इसका जो जमाबंदी है वो भी 18 का है। चलेगा। ये जो लाइन का दिखा रहे हैं, ये 84 से है। उसका पहले का तो नहीं है, 83। बने बने ये कौन है हमारे? ये बोल मेरा फादर है, नसीब नसीब है। ये मसीही दिन है, है। तो ये लैंड इनके पास कब से है? सब क्रेडिट तो 2014 में पास किया ना, तो लिमिटेशन के साथ तो देख के बाद ही होगा। उसमें हमको तो कुछ कर ही नहीं पाता है।
বিষয়ার ইমান তারিখ 15 censo indirect registration big number separation তার নাম আছে নাম
सेक्टर ऑफिसर का तो रिपोर्ट का एक रिपोर्ट आती है सेक्टर ऑफिसर का।
limitation
One 63, that of each plot of land. So bad. Why you go to the Jasmine Masuddin the father. Krishna. What is it? It is 2019 में दिया ना. तो इसके लिए नहीं देती. ठीक है, हम करेंगे. तो करेंगे तो बात कुछ है नहीं.
And his father expired in 2014. Proceedings father left 5 sons and 3 daughters. However, while discussing Exhibit 5, the learned traveler has held that the proceeding has not disclosed the material facts about the name of his brothers and sisters, his grandparents, etc. And that the proceeding has not disclosed about his parents, whether alive or dead by this time. Full stop. This is part of the observation of the learned tribunal. It appears to be contrary to the statement made in paragraph 8 of the written statement, where the petitioner has clearly stated that his mother, Sahira Nessa, expired when he was aged 18/19 years, and his father, Nasiruddin, expired in the year 2014 at the village Hatakuchi, Khatakuchi, under Rupshi Moza and Kolgasia police station in the district of Borpeta. Yes, the petitioner has clearly stated that at the time of the death of his father, he left 5 sons, namely Muhammad MD, Abdul Hamid, Muhammad Sultan, Muhammad MOH, MMAD, C, Muhammad Alimuddin, ALIN, D, opposite party, E, Ona Ali, and 3 daughters, namely Samad Kanchan, KANCHON, Kanchan Mala, B, Samad MUSSWT, Sahar Bhanu, SAHARDANU, C, Samad Posiron, KOSIRON, Nessa, this is legal player. Next one. According to Pama, as the finding of the learned traveler is in contrary to the pleading, court is of the constitutional opinion that it is for the learned member from a foreigner's tribunal to set the records right by basing its findings on the basis of pleadings and evidence on the court. Next, at this stage, the learned standing counsel for the FT and water matters has submitted that in this case, the petitioner had not exhibited any voters list to show that he is a voter or to link himself with his projected parents and siblings. It is also submitted that the name of the petitioner does not appear with any siblings in any of the voters list. Accordingly, comment is submitted that the petitioner has picked up to voters list of 1966 and 1970. Is making an attempt to link himself with his father on the basis of a Jamabandi. It is submitted that the petitioner has not been able to show that he was a resident of the place where the land is situated. Moreover, comment is submitted that the Gauhati certificate, which is like an exhibit 1, is inadmissible because of use of the state emblem of killer of Asoka, which makes the document inadmissible in evidence. Accordingly, it is submitted that they will accept for the inadvertence on part of the learned tribunal to record that the petitioner has not disclosed about his brothers and sisters, or whether that the petitioner has not disclosed about his parents, whether they were dead or alive. The finding of the tribunal is without any flaw. Next one. Whether as a play, this court, while exercising jurisdiction under Article 226 of the Constitution of India, is exercising statutory jurisdiction, not an appellate or review. Therefore, as that part of the finding of the learned, in the observation of the learned tribunal, while discussing Exhibit 5 that the petitioner has not disclosed meeting facts about the names of his brothers and sisters. And then the petitioner is not disclosed about as to whether his parents were dead or alive. Contrary to the pleadings made in paragraph 8 of the written statement. It was deemed appropriate that the matter be remanded back to the learned tribunal for a fresh discussion on the evidence after considering the pleadings available on record. Next, the learned tribunal is also expected to assign a reason as to why Exhibit 3, referred to in the evidence on affidavit of the petitioner was discarded. And why out of Exhibit 4.1 and 4.2 and Exhibit 5.1 and 5.2 from only Exhibit 4 and 5 were considered. And why and what necessitated the arrangement of the exhibit numbers, which would be clarity to the manner of marking of exhibits. Next time, the learned tribunal shall, upon accordingly, the equivalent opinion dated so page 26 is hereby set aside and the matter is remanded back for first opinion based on the written statement and evidence already on record. While doing so, the learned tribunal shall consider the observations made in this order. Next one. The petitioner, is duly represented by his learned counsel, is directed to appear before the learned foreigners tribunal, not technical. He said, the foreigners tribunal 2, Roman 2, Lakshmipur, not Lakshmipur, on or before. 7/4/2026. By producing a certified copy of the order.
My lord, 1 month time.
We're giving more than 1 month. 27th April.
Yes.
You wanted lesser. Today is
Yes, my lord. Oh, yes, my lord.
Today is 9. So
Yes.
you 9th of April.
Yes.
You want 9th of April.
Yes, my lord.
Yes, okay, then make it 9th of April. Make it 10th of April, 2026. The procedure certificate copy of the order, await for further orders or instructions from the said tribunal. Next one. The registry will send back the records expeditiously, along with a copy of the order to be made a part of the file. Next one. The next standing also for the FT matters shall, the border matters shall also transmit a copy of the order to the Home and Corporate Department. Next, requisitions partly allowed to the extent as indicated above. There shall be no other restrictions.
Thank you.
Item 4.
May please your lordship.
Yes.
So one advocate na Nagaon bar, taking with
We told you earlier also, we are not interested in that story. You must act in accordance with the High Court rules. The rules are made not for nothing. If you don't comply with it, you are, either you can start the argument or you not appear and then matter would be dismissed for the court. If you are not the holder of the brief, you should not be here taking time. What is your interest in taking an adjournment?
in 2020, he has taken the
That's
file
okay.
in my lord.
If somebody has taken the file, why you are
He-
here?
Then I have no communication, my lord.
Why you are here? Why are you here now? If they have taken the file, you have no interest.
So I filed the miscase and my name is stuck out the, is
You
stuck
do
out my
whatever
name
you
for the
want.
costly.
That you do whatever you want, but if you are not arguing the matter, we are dismissing it for non-constitutional.
I just want to gentleman for you. That is fine. I should, in this case, try to do
If you are not arguing the
Thank
matter,
you,
then we are dismissing it for default.
Kindly adjourn this matter today, my lord, and allow me to miscase file, my lord.
It's very difficult. Look at the order dated 18/2. That's why we know about all these things. We are already ready for that. 2019 matters there of adjournment. Either you do the matter or we dismiss it for non-constitutional. Madam, you can read the order.
Senior time হৈছিলে কথাটো মোৰ কথাটো কৈ দিলে বিজয় কৰা মানে the file খিনি ক'লে আজি ফাইলটো লৈ গ'ল.
It is the internal matter, lordship.
But we
But
passed an order.
yes,
What is
Lord.
the matter we are going ahead? So then you have no business to take adjournment. If they have taken the brief from you.
I had no communication from the court.
Lordship may pass appropriate orders.
We'll dismiss it, let them come and.
Yes, Lordship.
Revive it. Your name?
Miss DJ Bora. Miss DJ Bora.
Miss DJ Bora.
DJ Bora.
Miss DJ Bora, then counsel for the petitioner has submitted that the brief has been taken away from her. Full stop. Counsel for the respondents are present. Next paragraph. On 18/2/2026, when the matter was listed, the learned counsel was holding the brief had submitted that he has no further instructions in the matter, and the brief was taken away from him by Ms. D.J. Bora, learned counsel who had engaged in it. Accordingly, the matter was adjourned in order to be listed today. However, the petitioner was put to notice that if the petitioner remains unrepresented on the next date of listing, adverse orders will follow. Next one. Today, when the matter is called the learned counsel has that the brief was taken away from her. Stop. If that be so, the learned counsel for the petitioner has no reason to be present in the court and seek an adjournment. Having been disengaged, as she has been disengaged. Next paragraph. As the learned counsel for the petitioner is not ready to argue the matter, the court has no option but to dismiss this late petition for non-prosecution. Next paragraph. The registry shall retain the records for 30 days and thereafter transmit the records back to the learned concerned tribunal. Next paragraph. The learned standing counsel for the FT and other matters shall transmit a copy of this order to the Home Counsel of DB.
Item 5 for motion.
My lord, if the matter may kindly be taken at 2 p.m. Yes, my lord.
Item 7 for motion.
Yes.
May I please, your lordship? Lordship, one FT case has been registered, your lordship, against the instant petitioner, your lordship, and which was pending before Foreigners Tribunal number 2, your lordship, Nagaon. The notice is at itself is page number 17, your lordship. The verdict is page number 18, your lordship. That case has been registered at 290, your lordship, 11, your lordship. Now, that case was pending, your lordship, till 9/7/15. I appeared before the court, your lordship, tribunal, your lordship, and I filed my WS, defense witness, evidence, everything, your lordship. After that, your lordship, 9/7/15, your lordship, some of the staff, your lordship, that if Foreigners Tribunal number 2, your lordship, inform us that that case has been transferred to Foreigners Tribunal number 8, your lordship. Accordingly, we appear there also, your lordship, FT 8, your lordship. But there, what happened, your lordship, in FT 8, your lordship, one case in name of Amiruddin is there, but that is another person, your lordship, not me, your lordship. The address of that person is different, your lordship. So now, your lordship, I didn't get any opportunity to conclude my case, your lordship. And one more grievance is here, your lordship. In the voter list of 2011 and 2023, your lordship, that voter list is at page number 28, your lordship. Against the name of the petitioner, one D-Tech was there, your lordship, in the year 2011, your lordship. Even in the year 2023,
Which page?
it was 28, your lordship. Vanipula, your lordship. Serial number 496, your lordship. It is Vanipula, your lordship. Lordship, kindly find it out at page number 26, Your Lordship. Lordship got the D tag only at vernacular portion, Your Lordship. 28, Your Lordship. Serial number 496, Your Lordship.
Father's name is same.
That is another grievance. Legible memory.
Anything really cool or anything cannot make promise available. Lordship. Firstly, 9 and 10 cannot be made as party respondents. We cannot appear for our own matters. Respondent 9 and 10. They have to be striked off, Lordship.
No, her grievance is not against any of the orders, but she wants to know the
Status of her-
proceedings.
Yes, Lordship. Yeah, I just wanted to ask her whether she had filed her WS in the first proceeding.
Yes.
But it's not
filed it.
here, and that was in 11, Lordship, as per her statement at
So
page.
page 5, paragraph 2,
Yes,
that's your answer. On P3, the submitted written statement. Now, from this tribunal, we can just find out over phone as to where this matter is.
Lordship, it'll just take some time to find out where
Take it
it
next
is
Monday.
exactly.
We'll take it up next Monday.
Next Monday, Lordship. And paragraph 7, Lordship, her submission is that he was declared an Indian citizen by Fairness Tribunal number 8.
No. That the person, the other person, Your Lordship. He has been declared as Indian citizen, Your Lordship, not me, Your Lordship. Not
Who's
me.
his father?
Huh?
Who's his father?
Some different person. That
She
is.
said that she went to the tribunal, found out one Amiruddin, but he is not that.
Yes,
Amiruddin.
not in my
That
name.
Amiruddin got declared to be in India.
Extra person.
They
Yes.
have this duplicity of names, Lordship. We have seen it in our writ petitions also. I'll find it out, Lordship.
After
Lordship,
11 years, she has woken up to address the case. Let us see now.
we'll obtain instructions from both the tribunals.
Give her a soft copy also.
Lordship.
2 extra copies for the time being
Yes, Lordship.
and soft copy.
Instructions, Lordship.
For this G. Vora and counsel to be contested and also for the customer. In view of the nature of prayer made in this writ petition, comma, direct the learned counsel for the petitioner to provide two copy of the writ petition as well as one soft copy of the writ petitions so as to enable the learned standing counsel for the active and border matters to obtain instructions. Next one, list the matter on 23,
23, Lordship.
2026. The motion column. In course of the day,
Lordship.
take a short break and come back.
Item 8, or motion.
Okay. May it pleases your lordship. The order is very old, lordship. Impugn opinion is at page 23 of 17, lordship. And I have filed one additional affidavit wherein I have clearly stated why there was delay, lordship. And in fact, the petitioner belongs to the indigenous community, lordship, at paragraph 4 in my additional affidavit, page 78, lordship. I humbly beg for a chance to prove my citizenship, lordship. Paragraph 4 of my additional affidavit, lordship. Just a minute, let us copy it. Yes, lordship.
Which paragraph is your explanation?
Explanation, lordship. Paragraph 7 of my additional affidavit, page 80, lordship. Paragraph 9 also I have stated, lordship. And once he came to know about the High Court Legal Service Committee, thereafter he has approached their lordship for legal assistance. And in my writ petition also I have stated, lordship. Paragraph 7, paragraph 8, lordship. Paragraph 9 in my writ petition also. He is before lordship only with the support from the Legal Services Committee, lordship. On paragraph 6 onwards, lordship, page 6 of my writ petition, I had stated.
You are projecting in this repetition that your great grandfather was Munakkar Ali. Your grandfather is Muhammad Ibrahim Ali.
Yes, Lordship.
Your father is Zakir Hussain.
Yes, Lordship.
And your name is Rajiv Hussain. This is the four
Yes,
generation
Lordship.
factory. Please come to this Jamamandi, which is at page 74. This is your projected grandfather's name is Takov Monestar Ali.
Yes.
His two sons are there, the Sabidan Ali and Sabati Ali.
Ibrahim was denied this land in this particular land.
So your father is not there,
Yes, Lordship.
correct?
Yes, Lordship.
Then there's another thing.
Not,
No, this
not father. Grandfather is not there.
it's okay.
Grandfather is not there because grandfather was deprived that land.
It's okay. You're not on that. Come to page 76.
Yes, Lordship.
This is the voters list of 1966.
Yes, Lordship.
And the Jamamandi we just saw is also 1966-67.
Yes, Lordship.
But then not only your grandfather, but his son Bachumia has also expired.
Bachumia's son is,
None of that, but we are on the 66. 66 they were dead.
yes,
The name came as dead in the Jamamandi in the same year, and same year in the voters list is alive.
maybe when the first half, because 65, the voter list were prepared, Lordship. And in fact, that death certificate or the enumerator should know that the person died, then only the name will be deleted. Even after the death, personally, if I say my father died in 2009, but subsequently, many voters list, my father's name appeared. When we have stated to the enumerator that my father expired, then only his name was struck off from the voters list. So that maybe in the same year, because voters list are prepared early.
Yes, Mrs. Verma.
Lordship, it is not the case that the petitioner was not aware of the proceedings. He appeared, he took time to file WS, and then for more than 3,255 days, he just sat, Lordship. He's approaching this court after 9 years and after more than 3,000 days, and that delay has not been explained, Lordship. Merely seeking an apology, Lordship, then we will have a floodgate of cases. Lordship has dismissed a whole lot of matters on this ground, Lordship. Delay and latches not explained and not maintainable at all. He had ample opportunities, Lordship. Opportunities were there, time was granted, but he chose, and the documents which he's relying on now, he had all those documents at that point of time. All those documents of 2015, Lordship. And the certified copy is also taken out now in 25 of that opinion. That means all along he was very well aware of the proceedings. Lordship appeared, he knew he was, he has a proceeding against him. So in my humble submission, Lordship, the opinion of the tribunal is correct, Lordship, it has to be upheld. Just that, Lordship, I'll rely upon, after she finished, I will submit, Lordship. If Lordship allows this petition, Lordship, I'm telling you, we will have hundreds of ex parte cases to come forward with this simple apology, Lordship. May I submit, Lordship? If proper inquiry would have been conducted, Lordship, he belongs to the indigenous community of the state of Assam. Only because of religion, he is before Lordship. Only because of religion, Lordship, then I'll say, because if proper inquiry would have been conducted, then it would have been easily ascertained that he belongs to the indigenous community.
Yeah, they're not caring about the inquiry, unfortunately.
Yes, Lordship, and he belongs to the Goria community, Lordship.
They're not on community.
So, and a genuine Indian citizen should not be pushed to a
Otherwise, he will become stateless. Why the other country will accept? Because he is an indigenous person from this country. Only his misfortune is his religion.
No, Lordship, I think the kind of argument should not be entertained, Lordship.
Appreciated. The reason is very simple. You got an opportunity.
Yes, Lordship.
That time you did not raise those issues. Now, after 9 years, we are not ready to hear that the inquiry was not proper. Inquiry will come only when we set aside this and bury you on merit.
Lord,
We
this is
don't
the
have to
reason.
merit, your merit will be heard only by the tribunal.
Yes, Lordship. This is the reason I humbly beg for a chance, Lordship, so that he can state all these facts before the learned tribunal, Lordship.
The question must be that why you did not appear on them.
Because of financial constraint, Lordship, that I have.
I think on record to show that. There is nothing on record to show that.
Yes, Lordship. And he wouldn't have approached this honorable court only with the support of the legal service authority he is before Lordship. Otherwise, it would have been very difficult for him to approach this honorable court.
Sometimes what happens because of legal constraints, they don't approach you, but they can go up to the Supreme Court.
We don't know. These things are without, I'm not acquainted with those things. Examine and pass on this.
Yes, Lordship. Deeply obliged.
Item 9.
Explaining that probably this has not worked on. Oh.
Please, also. My lord, in fact, my lord, to explain the delay, my lord, we have filed an additional affidavit, my lord. Perhaps, my lord, it's not on record probably, my lord. Deeply obliged.
Item 10.
Yes,
My lord, this is an ex parte order, my lord. My lord, the impinging order at page 62.
yes,
Page 62 is the impinging order, my lord.
yes.
Lord, this is order dated 23/12/2024, my lord. This is an ex parte order, my lord. My lord, initially the notice which has been issued by the tribunal as received by the husband of the petitioner, my lord. I have stated in para 5. Para 5 of my writ petition.
Yes.
May I read, my lord?
Not required, we have seen that.
Yes, my lord. This is the genuine ground, my lord. My lord, for the facts and circumstances, my lord, the petitioner could not enter her appearance. So, my lord, I prayed for a chance only, my lord,
Lordship,
to
detention of
remand the matter, my lord.
Lordship. 24. No,
No,
Makes sense, Lordship.
Submitted that pursuant to this ex parte opinion, the petitioner has been taken into custody on 25/5/2025, and she is presently lodged at
That, my lord, that is at Soraipula. Now, my lord, Matia detention camp, Golpara.
the transit camp Matia Gwalpara. This one. Next one. This writ petition has been filed on 5/12/2025,
Detention Soraipula.
and the affidavit in support of the writ petition has been shown by the husband of the petitioner, namely Lal Mia. And it has been stated in paragraph 5 of the writ petition that the summons were duly served on the husband of the petitioner, but the husband of the petitioner did not inform her about the said notice and left outside the place of residence for livelihood. So accordingly, there was a default on part of the petitioner to appear before the learned tribunal and contest the proceedings. Next one. The learned manifest for the FT and bottom matters has opposed the prayer for setting aside of the ex parte opinion on the ground that the notice was duly served on the adult member of the family, and therefore there was due compliance of the provision of order 3 within bracket 5 within bracket G of the, sorry, E of the foreigners within bracket tribunals bracket close order for 1964. Is further submitted that the petitioner did not avail the provision of order 3 dash capital C of the foreigners within bracket tribunals bracket close order for 1964, which provides for setting aside of the ex parte opinion. Subject to filing of the application within 30 days of the said opinion. So accordingly, the prayer made in this application is approved. Next paragraph. The considered opinion of the court, as the petitioner has been taken into custody on 25/5/2025, pursuant to the ex parte opinion, and as the petitioner as well as her husband admit receipt of the notice. And they also admit the default on part of the petitioner to contest the proceedings. The court is of the considered opinion that the petitioner be granted an opportunity to file an application under section, under order 3-C of the orders within the guidelines order 1974 by providing that within a period of 20 days from the date of the order, in the event the petitioner pushes the learned member from a foreigners tribunal Gauhati and files an application under order 3 with the 3-C of the foreigners within the tribunal is order. Notwithstanding the limitation of 30 days prescribed therein, the learned tribunal shall entertain the said application and pass appropriate orders. This topic is also provided that as the petitioner is in custody, the in charge of the superintendent of the transit camp, Mati or Gorpara, shall allow the family members of the petitioner to take his signature on such application as may be required for presentation before the foreigners tribunal. And Ms. Verma, can you also provide that if an affidavit is required to be sworn, the in charge of that superintendent of the transit camp, Mati Gorpara, shall authenticate, and thereafter the affidavit can be sworn before the notary public,
Yes, Lordship, it has.
exempting her
Yes.
personal appearance. Next one. Is further provided that in the event the swearing of the affidavit is required, the superintendent of the transit camp, Mati Gorpara, shall authenticate the signature of the petitioner who is under his custody. Thereupon, it will not be a bar for the notary public to accept to authenticate the said affidavit by exempting personal appearance of the petitioner as she is in custody since 25/5/2025. Affidavit without exempting, you say in the event the affidavit is authenticated by the superintendent of the transit camp, Mati Gorpara, of the same shall be accepted by the learned member from foreigners tribunal Gauhati. Next paragraph. It is also provided that on an application under order 3-C of the foreigners within the tribunals, in order being filed, might not be open to the petitioner to pay for bail, and the learned tribunal shall pass appropriate orders as deemed fit and proper. Next one. The enforcement directions from this repetitions as partly allowed to the extent as indicated above. There shall be no orders to pass.
Obligement.
For motion, item 12.
Lordship, Advocate Jidesh Sharma is could not attend court due to some personal difficulties. Matter may be taken on any other day. 11? Yes. 11 mentioned executive.
Is that declare maker and counsel? This one, 21. 21.
Your Lordship, on 23rd March.
23. March 26.
Item 13 for motion.
Can it take up the matter after some time, right?
The report is covered.
In pursuance to your lordship's order, my lord, because we filed an application under order 14, my lord, your lordship's order was there in page 79.
Just a minute.
Conclusion. What is the entry?
There was a exchange of that.
Yes, doctor. My lord, that I understand is the conclusion exchange of two different names of husband. What was the inquiry about? My lord, with all humility, I am placing my lord. There should be something with the report for which there will be a prima facie case. When the body will shift to me, then I will go and face the tribunal. My lord, the issue is what was the report of the inquiry? Whether I am a foreigner or an Indian citizen. That inquiry, because the trial court also in order dated page 87, my lord, your lordship will find the trial court also.
See, this issue we have decided in many cases.
No.
This was a reference made by the
Well,
electoral registration officer.
My lord.
So that was under the Representation of the People's Act.
My lord.
There was an intensive revision of rules in 1997, and thereafter the electoral registration officer, he deputes a person to make an inquiry. These people are not police people who make that inquiry. And therefore, whenever there is a doubt created with regard to citizenship, under the then prevailing rules, it was sent to IMDT. Now, after that, there is a notification by the Election Commission of India that after Sarvanan Sonwal decision, then those references would be made before the foreigners tribunals.
No.
And therefore, even if the foreigners tribunal is blank and no suspect, nothing is suspected, still reference made by the foreigners tribunals, the electoral registration officer will have to mandatorily be decided by the Foreigners Tribunal.
Malad.
And therefore, the orders of the Supreme Court where you are relying on,
Malad.
saying that there should be
Ipso facto, there should be something.
something against that, that will not apply. And we have given it not in one order, but at least.
Now that I understand, Your Lordship, but at page, Your Lordship will find in page 87.
You see, the inquiry has been made.
And what was the finding arrived at, Malad? Your Lordship may look into the inquiry, what was the finding arrived at? Conclusion is that it was a mismatch between Amir Ali and Abbas Ali.
No, but
What
still
was the
there's a
finding
reference-
arrived at, whether he is an Indian citizen or it is
It's not required to be given by them. They send to the Foreigners Tribunal, they will decide.
Malad, there was the LBO's report was there, Malad.
Yes, and that's why you see, once there is a suspect, the Superintendent of Police,
Malad.
he does not act under the Foreigners Act, and therefore what he does is that he acts like a postman. He'll
Malad.
just say that the reference is sent to the Foreigners Tribunal. And it is for the Foreigners Tribunal to decide.
Malad.
He will not do anything because it's not his inquiry.
Malad.
He will merely say that he's received a report and therefore is forwarded.
Now, there was a report from the border also, the police. Border also there was a,
No, this is only an inquiry by the ERO.
border was also there, Malad, border police. From the, it was sent to the Malad and it was an order from the Gauhati city border, Panbajar. There was an inquiry from the border, Gauhati city.
Same inquiry which was placed on earlier occasion, Lordship.
From memo dated DCP 183/2025, 2767 dated 9/10/2025. That was the reference on the basis of which there was a submission of inquiry report by the Gauhati city border, Panbajar, Assam. To the Deputy Commissioner of Police, border.
You see, that happened because of the fact that that the Foreigners Tribunal at Gauhati passed an order on 19/8, 2025, and therefore this inquiry, because this inquiry was made perhaps at your instance,
My lord,
correct?
my lord,
Then you made an inquiry and therefore the tribunals.
on 11/9/2025, there was an order from the tribunal.
But you see, all this irrelevant because of the fact that this inquiry which is subsequently being made
My lord.
will not be material because of the fact that it's an ERO reference.
Already our reference was there.
Already was references.
Yes.
So because you appeared and disclosed that there is a discrepancy and therefore this inquiry made. And now it has come out that yes, there was a mismatch and there was a, what you call, the reference of two people were.
Amir Ali and Abbas Ali, two different.
Two different were substituted and therefore that has been rectified now.
So what remains in this case?
Let me contest the matter.
My lord,
We can give you an opportunity to contest the matter now.
my lord, that is there, my lord. Now. No more options are there.
Option is there. You can make us overwork by questioning that ERO report and you'll have to write this again, that 10 pages of order explaining why this has happened.
But ultimately, my lord, what I find from page 89 also, it was to mismatch and nothing was there. That was whole which is.
We'll pass the order so that is clarity, you would have made your point made. You would have accepted your point and we would have decided the matter. We'll give you an opportunity,
Oh.
but it takes some time to pass the order. It's
No.
following us.
Tomorrow is the day, my lord. Tomorrow is the day. Well, we will file an application for adjournment that much.
What said that represented? Mr. G. Sharma, understanding question for the applicant border matters. Just from. During inquiry, they are looking into the time of the time connect, actually, this also go West Bengal, the Manipur, input, but inquiry to question first. Even if the house is insurance get to Google, get the leg of some man, the country to go to Google. The inquiry is to follow about with others. The inquiry to follow. Instructions dated 2/3/2026. But Mr. P.K. Raychaudhuri, learning counsel for the petitioner and so for the respondents. List on 20. March 2026 for delivery of orders. Next paragraph. The learned counsel for the petitioner submitted that the proceedings before the learned August tribunal is fixed on 10/3/2026. This is 9th week, make it 13th, not 20th, 13th. Next, as the matter has been posted for delivery of orders on 13/3/2026. The court is inclined to provide that if a petition for adjournment is filed by the petitioner or the said learned tribunal, they will adjourn the matter till 16/3/2026. Next paragraph. This 13/3 for delivery of orders.
No.
Chamber. Continue post lunch. Yes, sir. Item number?
Obliged.
May please, Your Lordship. My lord, I'm sorry to say, can I mention one thing, my lord? Item number 21, my lord, actually, we have to withdraw this petition for some amendment, my lord, to find a place, my lord. Time may not be
Yes.
permitted, second of my lord.
Just wait till we reach the matter.
Okay.
Time being item 2.
My lord, the ex parte order was passed, my lord. Then he filed, my lord, one cancellation of the ex parte order petition, and that judgment was passed, my lord, page 53. My lord. Yes. Paragraph, my lord, as per the order of the member, my lord, learned member, uh, it was counted, my lord, past her absence, my lord. However, whatever, my lord, she took time during the trial before the tribunal, on her request, my lord, of course, my lord, few days time were taken, but all the days, my lord, by her application, she took time. Showing some causes. And when learned member dealing with this application for review of the order, all the, my lord, her negligence was taken into consideration. And it was rejected.
You have one. Your opinion? Your opinion? Opinion to get Opinion to our officer to review this. Review full plan, none to not. Opinion to get something like that. Sideways or agote, sideways agote. Next, हमने petition to agote this. Review 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 था बड़ा. क्या होगा सर? Doctor doctor exam दिवशी PW2 doctor PW2 doctor exam दिवशी ठीक है तो सब लोग exam जो पासी doctor है दिवशी बस फिर चलो ना तो doctor certificate था 25
Lordship, and this only Lordship, one document is existed, Lordship, page 25. Apart from that, Lordship, nothing has been placed by the proceeding. Only death certificate will not enough, Lordship. Since 2016, this certificate, Lordship, only says that Lordship, since 28/3/2016, due to suffering from dysfunctional uterine bleeding and anemia, so she was advised to bed rest. But other medical document is not available, Lordship. Only in the year 2018, Lordship, this certificate, she collected this certificate, Lordship. Apart from this, nothing is there, Lordship. And Lordship, That's also 12/9/2017 prescription is only for fever and cough, Lordship. Then 23/6/2018 anemia, severe anemia. Then Lordship, after that, some certificate of the year 2018, Lordship. Prior to September 2017, Lordship, there is nothing, Lordship. Actually, this, if we see from 23/6/2018, there are some prescription, and Lordship, opinion on was passed in the year of 2016, Lordship. Between this period, what he was doing, Lordship, that was not mentioned. And Lordship, in Ayub Ali's case, Lordship, it was clearly stated in 2016 1 GLT 273. 2016 1 GLT 273. Ayub Ali, AIUB, Ayub Ali, in bracket MD, and others versus Union of India. Lordship, para 16, I am relying principles of natural justice, and Lordship, facts and circumstances of this case is similar to this case, Lordship. Para 16, what does it say, Lordship? I am just reading. Principle of natural justice cannot be put into straitjacket formula. It is more than 3 decades that the issue of influx of foreign nationals has been in public domain in the state of Assam. Process of determination of question of citizenship cannot be a one-way traffic, leaning only in favor of a person whose citizenship is doubted. Interest of the state is also paramount importance in that unabated influx has the potential to affect the integrity and sovereignty of the country. Citizenship of a person, no doubt, is a very valuable right and should be jealously guarded. However, if a person does not take steps for safeguarding his interests, he does so at his own peril. A right to a fair hearing or principle of natural justice cannot be permitted to lead to a farcical situation and to be an engine for defeating the very object of identification and deportation of foreigners. The petitioners had known about the allegation against them that they are foreigners entering into India without any valid documents, at least from 2007, even ignoring the earlier part under IMDT Act from 1997. The petitioners all these years apparently did not take any steps to defend their rights in the court proceedings. In these circumstances, I am not inclined to grant any further opportunity to the petitioners as any such course of action, according to perception to the court, would be self-defeating. So, Lordship, here also, Lordship, in this case, if we see, this is the reference of 1998, Lordship. IMDT reference. And tribunal has passed the opinion in the year of 2016. And there is no document from 2016 to 2018 that person concerned is not physically fitted to appear before the concerned tribunal. So, Lordship, I think Lordship opinion may not be disturbed, Lordship. Yes, Lord.
Obliged. Yes, my lord. Document, my son's documents, any other document, my lord. He stated that, my lord, a handicapped son is the. But yes, my lord, no document. Obliged.
Item 14 for motion.
May I please, Lordship? My lord, this is a, my lord, expertise order, my lord. 2010, my lord. Yes, my lord. My lord, he is a government employee, my lord. I have annexed the, my lord, appointment letter, salary slip, everything. On 25/5/2025, my lord, he was arrested. My lord, my appointment at page 42, my lord.
Oh, that is the other things. First is that why did you not appear? Notice was served to you.
Notice, my lord, kindly come to court's order, my lord. My lord, I could not annex the notice, my lord, that the court's order says, my lord, page, my lord, 53. This is the type copy and original copy at page 55, my lord. Here, my lord, the record put up today, this case stands transferred to FT Gulaghat from IMDT Jorhat Bhait Gopt order number so and so dated 2/2/2006 and order of the Honorable Supreme Court of India passed on 12/7/2005 in the WPC 131 of 2000, my lord, 181 of 2000. Thereafter, my lord, the transfer FT case against Musammat Mallika Khatun issue notice to the OP fixing 13/8/2007 for service report. Service report, my lord. Thereafter, my lord, on 13/8/2007, অপর পক্ষ বিনা তদবিরে অনুপস্থিত ন্যায় বিচাৰৰ খাতিৰত উপস্থিতিৰ বাবে কৰা হওক ধাৰ্য টাং 2/11/07 my lord উপস্থিতিৰ বাবে my lord there is no mention my lord whether she has received the notice or she has received the notice or the notice has been served upon her. There is nothing.
All for the record, sir.
My lord, I have a IA, my lord. I have an IA for bail, my lord. She was taken into
At this stage, no.
my lord, the petitioner is, my lord, is still before her arrest, my lord, she has been serving continuously, my lord, on her post, my lord. My lord, appointment letter, I have annexed, my lord, kindly come to page 42.
That's okay, but once she has been taken into custody, we'll have to wait
Yes,
till the
right.
records come. We're not considering it right now.
As per order, Lordship, notice was duly served, Lordship. Yes,
It's the record.
Yes.
It's not will interfere. This is a filed only recently.
My lord. But the court order, my lord, doesn't say.
Comes for the petitioner and also from the respondents. I find that the revision in Article 226 of the Constitution of India. This has the same the party opinion. The 29/3/2010 passed by the managed member from our partner's family from Gauhati. 252. In the case number so-and-so. They were declaring the petitioner to be a partner post 25/1971. Next, the London Township for the petitioner has drawn the petition of the court for the said opinion and this the said opinion, as well as the order sheet of the said learned tribunal, which is annexed as annexure K to this petition, and it is submitted. There is no order showing that the notice was being served on the petitioner. So accordingly, what is inclined to call for the records of case number FTG 484 of 2007 from the family member from partners family in Gauhati. So before that, we make but there is no order for the same. There is no order there. It was duly served. So it is further submitted that the petitioner is this has been taken into custody on 25/5/2025, and since then she's been held at the holding center from our 7th AP Battalion from Saraikala from Pokrajhar. So it has been submitted that the petitioner is a government servant who has come to know about the ex parte opinion only after being taken into custody. Of course, you can sponsor it. So and so. The following email address. The registry shall send the position of the record. Next one. The petitioner is filed the connected interrogatory application number 603 of 2026 for the bail for the same charge proceeding. On the next date, on visit of the tribunal's records. Next one. This is the matter on the data for 3 weeks. Next one. Legal time. The petitioner provides not petitioner name is so also already defined. Will not be sent back. Your order before. The legislation shall produce the shall cause production of a certificate copy of for the in charge of the solving center our 7 days of the certificate copy or to the
Now, SP, concerned SP, Lordship.
concern SP, right? So the student of police border. One, 4, and 6.
Through them, they will communicate. Through them, through concerned SP, Lordship, they will communicate.
My lord, now she is lodging at my lord Matia, Gwalpara.
That's why we asked you, you said Saraikola.
Soraikala earlier, my lord. As per my latest information, she has taken to Matia. Yes, my lord. Oblige, my lord. Oblige.
Item 15 for motion.
Right. But it's by an impugned order dated 31/10/2023, my lord, the petitioner has been declared to be a foreigner of post 1971 history, my lord. Case by lord 83. Earlier also, my lord, the petitioner approached his honorable High Court, my lord, and by the order dated, my lord, 27/9/2024, my lord, this court was pleased to dismiss the said petition, my lord, as withdrawal, my lord. The petitioner withdrawn, my lord, to the said case with a view to contest the case on merit, my lord, at Foreigners Tribunal, Bazali, my lord, by filing a review with, my lord. My lord, is 97, my lord. 97. 98 is 11%, my lord.
Then what happened?
Then the petitioner approved the learned Foreigners Tribunal, my lord, at Bazali, my lord, by filing a review petition, my lord, which was numbered as a review petition number, my lord, miss case number 1/2024, my lord. But that case has been dismissed, my lord, as because a delay was there, my lord. Delay of 388 days, my lord. Kindly see the order, my lord. Which is page 99, my lord. Page 99. Last paragraph, that about the basic ground for not preferring the review application within the stipulated time taken is that he was suffering from severe illness for which he could not obtain the certified copy of the order on time, but surprisingly there is
Lordship,
25, they approached, got this order, last page.
as per DRP, Lordship, page 98, it was only dismissed on withdrawal, Lordship. Page 98.
Page 99.
99. Yes, Lordship.
They were approached and they, that was rejected. But it says it's not done lodging for the petitioner and so is the respondents. opinion at page 83 dated 31/10/2023, passed by so and so in case number so and so. Goodbye. And the case is in the middle, huh? I'm underlining. So and so by which the petitioner declared to be upon him.
बदलिए अगर तुम ये बकरा सी ये तो बदलिए हो गए सारी हो गई हाँ किसमान के बदली तो फिर किसमान भोगता था ना ये तो तब लगा पोजीशन में अपने इंफॉर्मेशन तो लो तो
The opinion was assailed by the petitioner by filing WPC 2607 of 2024. Comma. He said the petition was withdrawn just to enable the petitioner to file a review petition before the Honorable Tribunal. Accordingly, they said the petition was dismissed on withdrawal by order dated 27/9/2024. Stop the petitioner, then filed this case number 1 of 2024 before the learned tribunal. However, an order dated 11/6/2025, he said the petition was application for combination of delay of 380 days was dismissed. Next. Notice returnable 4 weeks from the 2 days out to the records to be calling even address. Therefore, bill is approved by the learning because the appeal for the case. Saying the position, 10 days time to get out this model, this satisfactory book. Build of police border, replace.
SP बदली हुई SP बदली हुई
Bozali, you have not made Bozali a party here.
Yes, Lord, Bozali has been created newly. Earlier it was Borpeta.
We don't know, unless you make them a party, we don't know anything.
Yes.
It is Borpeta or Bozali. If you have Bozali, then take, amend your petition.
Not made party. Earlier it was Borpeta, my lord.
Then we can't do anything, you have to amend it.
Borpeta, SP Borpeta may be directed, my lord, if it is
So
highly.
you take a risk, we
Transferred by
are not
then-
saying anything. You take a risk, it is at your risk and cost, we don't know.
SP Borpeta, my lord. What is Borpeta? Yes, Borpeta, my lord. Obliged.
Item 16.
Yes,
My lord, this actually is the injection on the part of the village, my lord. My lord,
other in those stole 59,000
Lordships,
and you have come to High Court.
your lordships, see page 4. Cause of action before 20 years.
Hmm?
Before 20 years. Cause of action. Page 4, my lord, para 3. And case filed against wife and mother-in-law.
my lord,
Mother-in-law.
earlier FIR was
Before
not.
20 years.
Registered.
That one
1/1/2006.
Tell us how much cost we should impose on you. Start from 2 lakh.
My lord, here, my lord, FIR was lost, but it was not registered.
That's why we are asking you now, what cost?
My lord, I may be allowed to withdraw it. That will be better, my lord.
This is SB Chaudhary from our council. What says that representative? At the outset, Mr. P. Sharma, another additional senior government advocate, has submitted that there is a specific statement in paragraph 3 of the writ petition that the incident referred to in this writ petition, that the father-in-law of the petitioner had stolen valuable articles amounting to rupees 59,660, occurred on 1/1/2006. Accordingly, this is being probably done at last 6 minutes of this position. Here is around.
Problem.
Item 17.
My lord, in this case, my lord, judgment at page 69 and paragraph 14 is the relevant, my lord.
Right.
Paragraph 14,
Came for here.
1414, my lord, page 70.
You are ready for hearing?
No, my lord, this is motion matter.
No. If you are referring to the whatever is inside, then that means you are ready for hearing. Then you take up for disposal. Order to the AM original and conflict with the response, for the response. Opening is at page 69, dated 29/1/2026, passed by so and so. In case number so and so, police inquiry number so and so, by which the petitioner was declared to be a problem of possible attack in 1971. Notice for weeks after the extra publication in police after the records. Prayer for bail is opposed by the London and the next period to university order. Please do not become the state of the SP. Superintendent of Police, border. Which
My lord, Gauhati, my lord, here, my lord, he is provided to register his name within 30 days. Because it is found that, my lord, he is within the, my lord, 66 and 71, my lord.
you are registered.
No, my lord, before 1 month, I filed this petition, my lord. So therefore, I am saying, my lord, this.
That can't be waived.
No,
You have
just
to file,
for the time being, my lord, I am praying, my lord, the operation of this part.
No. That can't happen. You take the risk, because we will refer to the case of 6A of the Citizenship Act and say that that order will follow. We can't extend the time given by the Supreme Court.
Because if, my lord, if your lordship ultimately is satisfied that, my
We are
lord.
giving you an option. Option is yours. You will have to elect. We'll give you what you want.
Then, my lord, for the timing, he may be allowed to register his name, my lord.
No, for that we don't know, we don't need a required order.
Otherwise,
This
my lord, he is claiming that, my lord, he is an indigenous person, my lord.
We don't know, 29/1, so 29/2, your time will stop. After that, we can't do anything.
My lord.
We
But,
can't extend the order. Mr. Barbia, you know more than us.
Yes, my
You know 66A, what the Supreme Court has said.
I filed this matter, my lord, before time, my lord, but it was not reached, my lord.
Can't do anything. We can't do what is prohibited by the Supreme Court of India.
Otherwise, my lord, he is, my lord, the purpose of this petition before your lordship is that, my lord, his claim, my lord, is before 1/1/1966, my lord.
That's okay, but we can't do anything more. You know the law. You have to tell us how to navigate the law.
And my lord, his school certificate, father's school certificate, page 78, my lord, his father read in a high school, which is now amalgamated in the year 1965, my lord.
Whether you are aware of consequences or not, we don't know. You see, the case of 6A was decided by confederation bench. Now, in this judgment, there are two parts. One is by the Raja bench, which has given an observation, given its verdict, and after that, the learned single judge of the bench gave an explanatory view, agreeing to the observation of the main judgment authored by the Chief Justice of India. And in that explanatory note, it's very clearly stated that persons who have not registered, despite there being an order, shall no longer be eligible for citizenship. So you have taken a great risk. You have, it says, immigrants who migrated between 1/1/1966 and 24/3/71 and who have been detected as foreigners but have not registered themselves with the registering authority within the prescribed time limit as per Citizenship Rules 2009 will no longer be eligible for benefit of citizenship.
Pardon me. 69. Yes, madam. Yes, madam. Purpose of subsection 3 of section central government. Purpose of section 3 of section 6, appoint an officer not below the rank of additional district magistrate as the registering authority for every district of the state of Assam. An application for registration under subsection 3 of section 6A shall be made in form 17 by the person to the registering authority for the district in which such person is ordinarily a resident within a period of 30 days from the date of receipt of the order. The foreigner star will declaring such person as a foreigner, provided that the registering authority may, for reason to be recorded in writing, extend the said period to such further period as may be justified in each case, but not exceeding 60 days. That a person who has. Yes, sir. Well. But only my lord, subject to my lord opinion, your lordship. If my lord disputing this opinion of the tribunal, that my lord he would be my lord before 1166 my lord. Of course, my lord, it is safe if for the timing he register, my lord, it will not go waste, my lord, if ultimately he succeed, and register, it is okay, but otherwise, well, I expected.
We won't adorn the advisory role. You will have to take a call.
Only, my lord, I am, my lord, for the timing, my lord, operation staying, my lord,
That we
because,
are
my
not
lord, if ultimately he succeed in this writ petition.
That we are not doing.
Your lord,
It is
lordship
impermissible, we have told you. It's a
lordship is
constitutional right.
satisfied that, my lord, I will advise him. My lord. Record may be called for, my lord, notice may be issued, my lord, in the meantime, my lord, he will approach.
Film defects also by which the petitioner was declared to be a foreigner. Huh? No, you have to change that order now. The foreigner who has entered India with a bigger from the specified territory of Bangladesh during the period from 1/1/1966 to 24/3/1971 illegally and without any valid document. So accordingly, the petitioner was directed to register his name as a foreigner before the concerned foreigners regional registering authority. Under the provisions of Rule 19 of the Citizenship Books, 2009, dispensing a period of 20 days from the date of order of the 1950. I mean, they don't take them for then you should notice the government should extra purpose. For the records, for the email address. In view of the nature of order pass.
Exceeding 60 days. 60 is more one. Now it's off. 1 to 60 days one examination.
There is no requirement for the petitioner to take bail.
Yes, sir.
Next response.
Thank you for the.
Diploma.
Daily list, item 18.
Lordship. Impugn order is page number 15, page 61, another 15, Your Lordship. 61. Election is proved to fail the linkage and also submitted documents not passed to approval.
Dated 36/2023, passed by so-and-so, in application of so-and-so, reference of so-and-so. That is, the petitioner was declared to be a former person in 1971. Notice returnable on so-and-so. After 4 weeks, you date. Returnable so-and-so. After obviously 2 days, call to the records. The fear for bail shall be considered on the receipt of the travelers records. If in the meantime, the petitioner, namely so-and-so, is apprehended, she shall not be deported out of the country without order of the court. If so, the petitioner shall cause production of a certified copy of the order before the Superintendent of Police border, Gauhati, bring the order to the notice of the said authority. This law so-and-so.
Obliged.
Item 19.
Yes, Mr. President.
Policy in fuel order annexure 5 page 38.
58.
Page 38, yes. Date will 31st December 25.
Mr. A. Rashid, General Counsel to the petitioner and so-and-so for the respondents. Same order. No, sorry, here we will be. Interval between 4 weeks. Opinion is at page 38. As by so-and-so, the case of so-and-so, district of so-and-so. The by declaring the petitioner to be a partner of this meeting and the Notice of the control of 4 weeks, the following month, the conference about following email address. Therefore, bail is opposed by the managed standing for the empty matters, considering the projection. Then this time, to take bail on rupees 5,000 to the satisfaction of Superintendent of Police border. Which place? Superintendent of Police border.
Yes, similar there is Lakhimpur. The response number 4 million. Police border, Lakhimpur.
Item 20.
Yes.
Lordship, opinion dated is 26/11/2025, page 20th.
Page 28.
Yes, Lordship.
Dated 26/11/2025, passed by Vice Representative Spencer. Then I declaring the district to be a ordinance 4/25/2021. So, police of the remote zone, here for bail is opposed by the Learners Candidates for the matters. This is the condition, 10 days time to take bail on to 5,000 to the satisfaction of
SP Border Dhubri, Lordship.
the Supreme Police Border, Jubilee. Staff of police at the city of the
Deeply obliged.
Item 21.
We allow to withdraw this petition to file a fresh one.
Mr.
Zero Ahmed.
T.U. Ahmed, Land Council for the Election. And so also for the response. The Land Council for the Election. Can the vote is to withdraw this requisition if you approach again. There is a route. Dismiss from the liberty. Statement that are on the list. Okay.
22.
Please, Lord. Lord, in the earlier proceeding, my lord, petitioner was declared as my lord, not foreigner. And in the said order, my lord, we have annexed, my lord, annexed 10. A relevant page is missing, my lord. So I may be allowed to bring it on record, my lord.
And what is missing?
One page is missing, my lord. Annex 10, page 42, my lord. Logo in it. Last question.
It's 44. Mr. R. Ali, Land Council for the petitioner submitted that due to inadvertence, one page of Annex 10
Annex 10, my lord.
is missing, and if we gives lead to the court to file an additional affidavit to bring on record the missing doc. Missing page. The repair is allowed, along with the additional affidavit, the entire next should be reproduced. We are saying entire, because otherwise it will be part. We can't take. This, as and when the said affidavit is filed.
Sure.
You want a date or you?
Lordship, may I fix the date, my lord? I will furnish tomorrow, my lord. I will file to.
File tomorrow.
I'll file tomorrow.
Next week, 23. This one. I did feel.
23, 24th will be.
25th.
25th, madam. Okay.
Item 23 for motion.
My lord, impugn order is my lord at page 53, my lord. It is ex parte order, my lord, in the year 1998. My lord, no notice was served to me, my lord.
Service report also, my lord, I have annexed, my lord. And declared, my lord, foreigner within esteem, my lord. But since I was not aware, my lord, so I could not, my lord, restart my name, my lord.
Where is the service report?
My lord, service report is page, my lord, 51, my lord. As per service report, my lord, one Northad Ali, my lord, was received the notice, my lord, who is, my lord, seems to be husband of the petitioner, my lord.
Yes. Then,
My lord, what happened, my lord, in this case, my lord, there is a matrimonial dispute, my lord, with my husband, my lord, since 1996, my lord, and my lord, after my lord, 1998, my lord, my husband died, my lord, during matrimonial dispute, my lord. And that might be the reason, my lord, the notice, even though received the notice by my lord, husband, so that notice was not served to me, my lord. And that is why, my lord, I could not appear and contested the case, my lord. And now, my lord, in the last part of December 2025, my lord, police, my lord, informed that FT case was, my lord, I have been declared as foreigner. Thereafter, my lord, I obtained certificate copy and appropriate position available. As per, my lord, service road, my lord, as per tribunal order, my lord, and to my lord, notice was to have been served before, my lord, the test proceeding. And if proceeding is not found, my lord, then, my lord, family members, adult family members may be received, my lord. But there is no attempt was, my lord, to that effect to serve the notice to the proceeding, my lord. Paragraph 18, my lord, I have, my lord, explained, my lord. My lord, husband died, my lord, on 12/12/1998, my lord. Death certificate also annexed, my lord. My name also recorded in the final NRC, my lord. And I am, my lord, casting my vote till that, my lord. You may not succeed here, but you have a very good future. Just write, you have to just write for stories for some movies. You will be successful. May not be in this matter, but you will be successful. Come to page 42. Yes, madam. 42, serial number 4 is Mofidur Hussain, 28 years. Yes, madam. In 2021. That means he was born in 1993. Correct. Now come to serial number 2, Khairul Hussain, 22 years. Yes. He will be born in 1999. Now please tell me, if you were 1999, if he is born, that means after his birth is after the expiry of husband, number one. And number two, if in 1999 he was born, how could you live separately and yet this child is born? From 1996 you are separate. How in 1999 this child can be born? My lord, is my lord, sometime my lord. We don't know, sometime or other time, but this time we are looking at it.
Sorry, you failed here. There appears to be some discrepancy again. You see, in this page 42, you have a daughter named Jasmina Khatun, Laili Begum, Momina Begum. Incidentally, their names are not there in your family tree. Sorry, Mr. Hussain, we'll have to
My
discuss
lord,
it.
she may be the wife of my lord Mofidur, my lord.
We don't know. This is
Well,
for you
okay.
to tell us. This is your family tree. Mother cannot, normally is not younger than the son.
Due to the discrepancy, my lord, one
We don't know.
may
You
not
will
be
have
my
to tell
lord
us this.
declared as a foreigner, my lord.
You see, you will have to tell us the facts. We only see what you produced.
My lord,
But
page,
you can't accept.
page 23, my lord, total list of 1966, where is my father's name recorded, my lord.
No, that's okay. But
Yes,
when you don't contest the proceeding,
My lord, since I have not received the notice, my lord.
but
So, my
your
lord, the
husband
question
received
of
his due service under the 5
notice up to my lord, my husband.
permissible.
As per record, my lord, record says notice is up to the husband, my
Permissible.
lord.
Your husband was
And the
there.
husband, there is a matrimonial dispute, my lord.
We don't know about it. You just found a hole in your matrimonial dispute. If you have a matrimonial dispute, then it is a dispute where you are separated from your husband but having conjugal rights. That's your story. You don't know.
My lord, my name is also, my lord, continuing till date, my lord, in the voter list, my
Understand,
lord.
but every good thing is lost because of that non-appearance. Matrimonial dispute, you have to successfully first. It can't be a matrimonial dispute with visitation and conjugal rights. Sorry, we'll be dismissing it. Since we have less time, we'll pass orders in the chambers.
Published, my lord.
Item 25. Item 24.
May I please, your lordship? Lordship, here we have challenged the order dated 16/10/2025, passed by Ghazali. Page 96, impugn order. R. Islam. Yes, Lord. Lordship. WS Lordship. Place Borpeta. Oblast.
Item 25.
May I please read, Lordship? Lordship, imprint order dated 30 April 2025 at page 87. Lord. 87. M. Rahman. M. Rahman. Hotel.
Item 26.
Okay, Your Lordship. Lordship, I have been declared as a foreigner, Your Lordship. That order, Your Lordship, will find on page 66. Thereafter, I have filed a review petition, Your Lordship. That has also been dismissed, Your Lordship. That order is on page 71. So the
I said and also for the question. You're challenging both the orders.
both the
Opinion at page 66. Dated 18/11/2023. By which the petitioner was declared to be of post 25/371 stream, as well as order dated 21/8/2024, passed by the said learned tribunal in miss case number 2 of 2024, thereby rejecting the review application. Notice returnable on fixed date after 4 weeks. Return also extra copies and evidence, copy records. 27 which shall be considered on the receipt of tribunal's records. However, if in the meantime the petitioner, namely so and so, alias so and so, alias so and so is apprehended, she shall not be deported out of the country without order of the court. Next, the petitioner shall cause production of suspect copy of the order for the movement of this border. Page 4.
page.
The order to the notice of the said list also this.
Item 27 for motion.
May I please, Your Lordship, sir. In opinion is at page 71. Is order dated 25/6/25. Page 71.
And the second how then comes to the petitioner and swings over the response. Is 71. Dated 25/6/2025, passed in not by so and so, in case number so and so, inquiry number so and so. We were declaring the petition to be of partner for 25/71. Notice 4 weeks of the report. Then it's time to take bail of ₹5,000 to the satisfaction of Superintendent of Police Border, Sirsa.
Apply.
Supplementary item 42 for motion.
Your Lordship. My lords, may kindly see page 25 is the imputed order. And the case is, my lord, I did not receive any notice. Lordship will see third para. Notices were issued to appear, but none appeared. Notices were issued, but whether he received notice or not, that is not there. And over and above, my lord, my own sister has been declared as an Indian. That is page 6.
First, we'll have to see whether notice is served or not. We'll call for the records. Then
Some protection will be given.
no, can't protect. You will not be deported if you are apprehended. Third, standing Mahmood, then counsel the petitioner and so for the respondents. Party opinion dated 7/1/2015. Passed by so and so in 52nd case number so and so. IO case number so and so, by which the petitioner declared to be a farmer for 25 to 97 stream. The counsel for the petitioner submits that the said order does not, the said opinion does not disclose as to whether the notice was duly served from the petitioner. Accordingly, the court is inclined to call for the records of the case number so and so from the said learned tribunal, for which requisition may be sent to the following email address of the said learned tribunal. Next paragraph. If in the meantime the petitioner, namely so and so, is apprehended, he shall not be deported out of the country without order of the court. The petitioner shall cause production of a certified copy of the order before the Superintendent of Police Border Kachar, bring the order to the service of the authority. List on students. Your date after 3 months. Then first step will be part of the referee.
Obliged.
Actually, there was an upgradation of 41. The petition has expired, Your Lordship.
Yes, what do you want to do?
So Lordship, this is the lot certificate, Your Lordship. The Lordship, since there is a view in the earlier case of WPC 4240/20, right, there was a view that no substitution is being required as the petition had already expired, so that was being disposed of. So similarly, Lordship, this may be disposed of.
Okay, but you are aware of the consequences.
Yes.
Just give the death certificate. Give us a copy. We'll give it on record. Give us a copy.
Okay, sir, yes. Yes, sir.
Mr. Thanks, Ahmed, you are counsel for the petitioner. Upon instructions, I have submitted that during the pendency of this writ petition, Shamsher Ali has died on 5/11/2025. And in this regard, he has produced a copy of the death certificate. The learned counsel for the petitioner shall provide a photocopy thereof to be written on record. Next paragraph, the learned counsel for the petitioner submits that owing to the death of the petitioner, the matter has become infructuous. Next paragraph. The notice of the learned counsel for the petitioner is drawn to the fact that there are consequences attached to the opinion. Next paragraph, there is a plea in view of the affair made by the learned counsel for the petitioner, the matter stands closed, having been rendered infructuous, funding abated on the death of the petitioner, namely so and so. Next paragraph, the registry shall send back the records to the concerned tribunal along with the copy of the order to be made a part of the court.
Much of it.
My lord, regarding item 37, your lordship, let it be come on next Thursday, your lordship. Dividend date is listed but not reached due to paucity of time, your lordship. Next Thursday, your lordship.
You don't know about the dates, but they will take care of it.